Versus Briatico over the Teams platform, so everyone is appearing by video remotely. I'm going to ask everyone to identify themselves for the record, just so we can make sure we can hear and see each other okay. I'll start with the judges, then I'll ask for the appellant, then counsel for the appellee. I'm Judge Bright.
I'm Judge Albert.
Justice Palmer, you're on mute, if you could.
Sorry, Judge Palmer.
Mr. Francis, could you identify yourself, please?
Oh, Ernest Francis, Your Honor.
Assistant Attorney General Zenobia Graham Days, here on behalf of the defendants.
Okay, I can hear and see everyone okay. I'm assuming that's true for everyone else. If at any time anyone cannot hear or see any part of the proceeding, please let us know. If you get disconnected for whatever reason, we'll stop the proceeding and wait till everyone is back on to resume the proceeding. Each party has 20 minutes to argue. The appellant can reserve time for rebuttal. I will keep the time, and I will hold up signs at 2 minutes, at 1 minute, and when time is up. Okay? So with that, I think we're ready to proceed. Mr. Francis, you ready to go?
Yes, Your Honor. I'd just like to reserve some time. I'll probably going to go for like 5 minutes to reserve some time, if that's okay.
Sure. Yep.
Okay. Thank you. Good morning. May it please the court. Chief Justice Bright, Justice Alvarado, and Justice Palmer. This is a 42 U.S.C. 1983, which was actually filed in the state court for the Judicial District of New Haven, alleging violations of my constitutional rights as it applies to the Eighth Amendment. In this appeal, I'm asking the court to interpret to what effect does the Whitley versus Albert standards apply to non-use of force cases where prison officials have the duty to protect. On August 8, 2013, there was an electrical fire in the Cheshire Correctional Institution in the North Block 1 unit. This electrical fire caused severe injuries to, well, it caused injuries to 14 inmates, 1 correctional staff, and resulted in 3 workmen's compensations claims that were filed. The case was disposed of in the New Haven Superior Court by the Honorable Judge Nawaz Walla. It was disposed of by the weight of summary judgment. At this time, the court utilized the Whitley versus Albert standard, which is an enhanced standard to adjudicate this case. 7 different circuits within the federal court have utilized different standards for review under the Eighth Amendment when it comes to prison cases. In the Seventh Circuit, at least, they have utilized the standard of criminal recklessness as a standard. Our Second Circuit has not really identified which standard they want to use, which makes this case a little bit more complex. But what I'm asking this court to do today is to not utilize the heightened Albert standards, but to utilize deliberate indifference standards and more of a criminal recklessness type of standard as opposed to the Whitley versus Albert standard. As I stated earlier, the court used the heightened Whitley versus Albert standard, and in Whitley versus Albert, there was a riot in a prison. A prisoner was shot in the leg as a result of the riot, and he sued prison officials, alleging that prison officials were deliberate indifference to his needs. However, in Whitley versus Albert, this heightened standard was justified. It was justified because of the fact that there was a riot, and yes, prison officials do have deference to use force in certain manners. However, to use a use of force type of standard where intent is utilized, in this case, would provide an injustice. I would just like to ask this court to review Appellee's Appendix 86. In Appellee's Appendix 86, we look at Correctional Officer Briatico's report. In Correctional Officer Briatico's report, as soon as the fire started, the first thing that happened was Correctional Officer Briatico called maintenance. The officer did not call a code red, which is a code for a fire, meaning that this correctional officer did not view this as an emergency situation. And again, that's Appellee's Appendix at 86, and that's part of the incident report. So here we see one defendant who did not give an affidavit in this matter felt like this was an emergency situation. It was not an emergency situation. If we look at Appendix 79 and we look at line 22, Captain Viger describes the incident as sparks coming out of an electrical unit. Captain Viger himself did not see this as a serious issue. Also, at line 41, he later states that the speed upon which it was contained made it unnecessary to evacuate the unit. So the empirical evidence in this case is that both defendants did not see this as an emergency issue. So to use the heightened Whitley versus Albert standard, which is an objective subjective test to dispose of this matter, to me, raises the bar for prisoners. So what I'm asking this court to do is to look at the subjective nature of this. Subjectively, we have a situation where there are material facts in dispute. We have Viger and we have Riadico saying this was an emergency situation, but we have the court disposing of the matter under the heightened Whitley versus Albert standard, which applies to emergency situations. So in my opinion, there was material facts in dispute, and this case should have went to trial for the jury or the court to determine whether or not there were issues for trial.
Mr. Francis, I have a question for you.
Sure.
If we were to agree with you that the more traditional deliberate indifference standard would apply, do you agree that we would still review the evidence submitted in support of and in opposition to the motion for summary judgment to see if there's a genuine issue of material fact applying the deliberate indifference standard?
Sure. I have no problem with the deliberate indifference standard, but this is a heightened standard, and I believe that was too much of a burden to prove because I had to prove that the defendants were sadistic or wanton. And I think in a case where there's a failure to protect that, that's almost an impossible standard to prove. So that's what I'm asking for. I'm just asking for a review that's not at the heightened standard that Judge Walla reviewed it under, which was Whitley versus Alvarez, which is a use of force case where he alleged prison officials were sadistic. I'm not saying that here. I'm saying yes, it's possible a mistake was made. It's also possible that some officers were intentional, but at the end of the day, that was an issue for the jury or the court to decide, but not an issue for summary judgment because there are material facts in dispute as to how this transpired. And I should note that Judge Walla referenced Honorable Supreme Court Justice Ecker's memorandum of decision and used my cries for help as a reason to raise the bar, so to speak. But as the defendants point out in their brief, like it's not my subjective opinion. It's not what subjectively I say. It's more or less what subjectively was in the mind of correctional officials. And I agree with that. So at the end of the day, what I'm asking for this court to do is just reverse and remand this case back to the Superior Court so the proper standard can be utilized, because I don't want to make bad law on this issue. Thank you.
No, but my question was, why can't we just, even if we agree with you that the improper standard was utilized, why can't we just apply the proper standard and determine whether summary judgment should have been granted applying the proper standard?
Oh, sure. I have no problem with that.
Okay.
I mean, that's excellent. Actually, yes.
Okay. So if you have nothing else, you'll have an additional 8 minutes. So you'll have 13 minutes for rebuttal.
Thank you. Appreciate it.
Attorney Graham Days.
May it please the court, Assistant Attorney General Zenobia Graham Days here on behalf of the defendants. At the outset, I want to just acknowledge the fact that the record does show that on August 8th, 2013, a code was in fact called. It is documented by Correctional Officer Briatico in his incident report on A86. It's also documented by Captain Viger in his affidavit, and that's at page A88, as well as page A79, paragraph number 25. A code was in fact called. When it comes to the Eighth Amendment, the subjective prong, the prong that is at issue in this appeal, we take the position that the Whitley standard should apply. But even if we apply the standard that was articulated by our Supreme Court in Estelle versus Gamble, we know that the conduct that was undisputed shows that these defendants did not conduct themselves in a manner that would even remotely equate to criminal recklessness. Criminal recklessness is a very, very high standard. But we understand that when it comes to the subjective prong, it's not a fixed meaning. We have to look at the circumstances that are outlined, and we have to look at the conduct from the vantage point, from the perspective of the prison official. And under these circumstances, we're saying that the Whitley standard is the appropriate standard, because when we look at their conduct, it was conduct that was done in haste. It wasn't planned. They didn't have another opportunity to second guess themselves. They had to move very quickly. And when we look at the record, it shows that that is exactly what they did. But Mr. Francis wants you to look at the fire and the fire alone. And that's impossible, because they're looking at things in totality. They're looking at the fact that there's a fire that's limited to one cell. They're looking at the fact that it's close to a shift change, close to a head count. They're looking at the fact that they don't know if this is some sort of nefarious type conduct that's going on or a genuine fire. If we look at the record, we know that the response to the fire was very, very swift. But what we also know from page 888 is that even after the fire ended, the deputy warden continued to keep that unit on lockdown. So it shows us that even though the fire was contained, there's still other things that are going on in order to make sure that everyone is safe. That's another issue. What we're looking at is the competing interests that are going on at this time. It is the response to the fire, as well as the ongoing desire to maintain safety and security, try and respond in a manner that does not require disruption to other areas of the facility. And so when we are looking at this record, we're saying that Judge Weiler applied the right standard. But even if we look at this through the lens of just the basic subjective standard articulated in Estelle versus Gamble, this is not criminal recklessness. We know that the defendants extinguished the fire. They brought in exhaust fans to ventilate the unit. They contacted medical staff to come in and triage the inmates. We know that the plaintiff was examined by medical staff 15 minutes after the code was called. And that shows that when we are looking at what these defendants actually did, it does not rise to the level of criminal recklessness. But we're asking the court to focus on the conduct of these defendants and the fact that they viewed it as an emergency in the heat of the moment. And it's documented. The response was very swift. If we look at page 886, we can see the number of staff that had to respond to this. That in and of itself is indicative of the fact that this was, in fact, an emergency. And because it's an emergency, we believe that the Whitley standard should apply. And when we apply that standard, we know that these defendants did not act in a manner that was sadistic or even remotely close to that standard. We're asking this court to affirm the judgment because there are no material facts that are in dispute. These defendants are entitled to judgment as a matter of law. And if there are no questions, I will rest.
All right, I don't see any questions from the members of the panel. So, Mr. Francis, you'll have 13 minutes.
So when we talk about criminal recklessness, I use that term loosely only as it applies to the Seventh Circuit. I'm not sure that Estelle versus Gamble says criminal recklessness, but if we talk about recklessness in general, then I would like to forward to Administrative Directive 5.3. So if we're looking at recklessness, we have to look at it from a state perspective, right? Administrative Directive 5.3, as it applies to evacuation of a unit, specifically states that this is what a correctional officer is supposed to do in case of a code red or fire: evacuate the unit. Now, they didn't have to evacuate outside, but they could have evacuated to the gym, but they chose not to evacuate at all. And these type of cases, I think they're unique because I like to look at it from like a COVID situation, right? Individuals catch COVID within the house unit, and let's just say staff refuse to wear a mask or whatever. So what do we say now? That it was purposely done? So whenever we're dealing with 8th Amendment failure to protect claims, I think that we have to be careful on how we view them, because if not, prisoners in state court will have no remedy for federal issues. So we'll be left without a remedy at all, because we'll be relying on proving that the officer was sadistic or intentional, and some things aren't intentional. We need protection from the 8th Amendment. That's not a heightened standard. And I think Whitley versus Alvarez is the wrong standard because of the facts that surround Whitley. There was a riot. There was tear gas. And to compare that to a failure to protect in a fire or a COVID situation, it increases the bar. So what I'm asking the court to do is just look at the national consensus, or to look at the evolving nature of the law, and to come up with a remedy and say, hey, look, in these type of situations, the deliberate indifference standard should apply, and not this heightened standard, because it's an impossible standard for prisoners to meet, and it only makes correctional officials more lax in their jobs. And I think that as a society, we need to start bringing these laws up and not diluting them.
Mr. Francis, what are the specific facts that you rely on to meet your burden of under the lower standard, under the Estelle versus Gamble standard?
So under the Estelle versus Gamble standard, I would look at the state law, Administrative Directive 5.3, and just the obligation under the 8th Amendment for prison officials to protect inmates. So there's certain things in play, like if there's a fire and the alarm rings, evacuate. That's for the safety and protection of inmates, right?
Just interrupt for, excuse me, 1 second.
Yes, no problem.
Is it your point that because there was no evacuation, that is itself sufficient evidence to satisfy the subjective standard that you claim applies?
So yes, the failure to evacuate the unit, the evacuation process itself would have took us out of harm's way, right? Even if you would have evacuated just half the unit where the smoke started from, I mean, that itself, I'm saying, was the reason why inmates and staff were injured, because you failed to evacuate. So yes, I'm gonna have to rely on that. I'm gonna have to say that the failure to evacuate was one of the sole causes of the injuries on that day. So for that reason, the failure to evacuate and the nature of saying, okay, well, we're just not gonna evacuate because we don't want to, then that would be the sole reason, yes. Or one of the reasons.
Did you suffer any injuries?
Yes, I had labored breathing that's documented within inside of the medical report. Also, I had scratchy throat from the fumes, because the fumes were actually coming through the ventilation as a result of being inside of there. And I had headaches, and for weeks afterwards, it took weeks for my lungs to get back to normal capacity.
Okay. Thank you.
You're welcome. So with that being said, what I'm asking the court to do at this point is just, if the court can utilize the proper standard and not use Whitley versus Alvarez, and to use just the standard under Estelle versus Gamble or whatever other cases it chooses to use. But I think that there's an issue right now because the Second Circuit hasn't clearly defined, at least my limited research, I have limited resources here, hasn't really defined the use of Alvarez like all the other circuits. But the Seventh Circuit has used criminal recklessness. At least the Third, Ninth, and I think Eighth Circuit was using some mixture of them, but our circuit hasn't really come to terms of how they want to apply this. And I'm asking this court to do that right now. I know it's a tall order, but that's what I'm seeking, because I'm of the opinion that Whitley versus Alvarez should not apply in this case. Thank you.
All right. Thank you both. It was very well argued and interesting. We will take the matter under advisement, and the court will stand in recess. We'll go into the courtroom for our last two cases of the morning. Have a good day.
Thank you.